So I will adjust your bond to a personal. It'll be $10,000 personal bond, and you're gonna have a curfew from 10 p.m. to 6 a.m. in the house. If for some reason you obtain employment in which you work during those hours, you need to contact the court through your lawyer to get your time and curfew changed. Understand that?
Yes.
Anything else?
No. And when would that go into effect?
It goes into effect as soon as you are released and a tether is placed on your ankle. So right now, it's taking about a week. I'm putting in the paperwork right now, so the process will begin as soon as the clerk enters in the system. But the tether unit, they've told us that it's taking about a week to get a tether, and I have no control over that.
And how long would I have to have the tether on?
That depends on what happens.
I mean, it's just my first time going through all this stuff, so I just wanted to ask.
Miss Ashley, we can talk, okay? I will call and set up a Zoom visit with you, okay? Thank you very much, Your Honor.
So Ms. Ashley, to answer your question, if your case is dismissed, of course, it gets removed, but it depends on what happens at the exam stage. Your exam is set for May 4th. So up until May 4th, if nothing changes with your case, you'll still have a tether on until then. Then you'll be in person on May 4th. You understand that?
Yes, ma'am.
So Ms. Ashley, if you are released, which you should be by May 4th, you have to come in person on your own to 36th District Court at 11 o'clock for your exam, okay?
Yep, I got it written down.
Okay, all right, you're all set, Ms. Ashley.
Thank you very much, Judge. Everyone have a wonderful day.
Yeah. Thank you.
Thank you.
Good morning. Williams, I think you might be in the wrong courtroom. Good morning.
Good morning. How are you? I just got told that I was supposed to be in courtroom for last name Williams.
Yep, that's 332 now. Judge Williams is in 332.
332. Thank you so much.
You're welcome. To the gentleman in Division 2, Wayne County Jail, what is your name?
Kobe Boyles.
Anybody here for Mr. Boyles? Oh, Myers. Dakota Myers? This is case 2356241, people of the state of Michigan versus Dakota Myers, who is charged with 1 count of stolen property, receiving and concealing a motor vehicle set for a probable cause conference today. Appearances?
Edwin Milwaukee, P5482A, appearing on behalf of the people.
Good morning, Your Honor. Aliyah, P77614 on behalf of Mr. Myers, who appears via Zoom. Mr. Myers, can you please state your name for the record?
Dakota Myers.
Okay, and do you have discovery?
Your Honor, I have some paper discovery. There's some missing.
What do you mean?
There's a police report for a stolen vehicle. Some of the discovery contained errors. It's all before their exam that's set on May 1st.
I guess.
Oh, yeah, we're aware of the missing report is some of the inaccuracies or whatever mistakes. And we have reached out to the OIC twice. I did late last yesterday afternoon. We still haven't heard anything back from the officer in charge.
Exactly, it's paper discovery that you're missing?
Paper discovery, and I don't know if they're in possession of a green light video that was mentioned.
Would you like a discovery order sign?
Yes.
Okay, I'll sign the discovery order. If you could, email it to the court, I'll sign it, and email it back to everybody. And that way, these people will have something to provide to the police officer and hold them to it. Do you want to keep the same date? And
Mr. Myers has traveled back from Indiana to participate in preliminary exams, so if we can have that.
he's here.
He's in Indiana.
Okay, so he moved to Indiana.
He's a resident of Indiana.
Okay. But I'm confused as to why that matters. If he's not
He
here.
has to travel,
now.
he has to travel, yes, well, if we hold a preliminary exam on May 1st and this is not resolved, he's gonna have to travel back here for the exam.
He may not have. If you were saying,
Okay,
if there's a discovery missing, then you can make a motion.
okay,
And he's provided, he's provided, it's the second.
yes, it is.
So we're gonna keep it May first.
Thank you.
Mr. Myers,
Yes, ma'am.
your exam has been set already for May 1st at 9:30 a.m. in person at 36th District Court.
Okay.
Once I receive that discovery order, I will sign it and provide it to everyone, with the people, with the copy on it, okay?
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Cross that, Mr. Dakota Myers.
What'd you say?
You're all set, Mr. Myers.
Okay, you have a great day.
You too. Ready on Boyles?
Yes, Judge.
The people of the state of Michigan versus Kobe Ray Kwan Devon Boyles, case 2355721. Mr. Boyles is charged with count 1, motor vehicle unlawful driving away. Motor vehicle, count 2, also motor vehicle unlawful driving away of an automobile, and count 3, assault with a dangerous weapon, felonious assault. Count 4, police officer fleeing 3rd degree. Count 5, malicious destruction of fire or police property. Count 6, police officer assaulting, resisting, and or obstructing. Set for a probable cause conference day. Appearances.
Edwin Zawaki, P548, appearing on behalf of the people.
Blaze Kearney from the Neighborhood Defender Service of Detroit, P83960 on behalf of Mr. Boyles. I'm standing in for counsel of record Andrew Sullivan.
And Mr. Boyles, can you have the deputy unmute your device so that you can say your name, please?
And Judge, while that's happening, if I could just inquire to make sure the information we have is correct, because the 36th District ROA is down. Is the bond currently a $10,000 cash bond?
That's correct, yes.
Okay.
From a case is from March 21st.
I'm unmuted, Your Honor.
Okay, can you state your name, please?
Kobe Boyles.
Okay, we can address bond, after we discuss discovery and exam date.
Understood, Judge.
Okay, do you have discovery?
We do have discovery, Judge. Discovery was previously provided following a probable cause conference. I just had it up a second ago. I apologize. 1 second. We have paper and we have digital discovery. I haven't had a chance to review it. There is a significant amount of dash cam and body worn camera, which I guess we would expect in this sort of a situation. I did prepare a initial discovery letter and a proposed discovery order for the court to sign, just in case there's anything outstanding. And so I would request, number 1, the prosecutor's email address, and then 2, where the court would like me to send a proposed discovery order if it was interested in signing one.
So I will send it since the people are not on Zoom. What is your email address?
SELWOCKI.
Thank you. Thank you, Judge.
Well, I'm sending my email too.
So I think we're just interested in setting an exam date, Judge. Mr. Boyles does have a sentencing set in the Third Circuit Court on May 1st. I don't think there's, Mr. Sullivan is back after May 1st, so I would request a date after that. I see. Let me just double check his calendar, make sure one of those dates works. I think the May 5th at 10:30 would probably be best.
Okay. May 5th at 10:30 for exam. And I'm sure you want to address bond, correct?
That's correct, Judge. Mr. Boyles has returned into custody. He when got very nervous prior to his sentencing, when it was time for him to do his pre-sentence interview report. He's very, very young. He's 18 years old. He learned that he had a child on the way, and combined with the sort of fear of going to prison, which ironically he had a cop's agreement with his circuit court judge for 2 years of HIDA probation. Decided not to come to court. I think out of that fear. I think that is more a reflection of youthful indiscretion rather than some sort of manifest unwillingness to like thwart the justice system. I think that he has spent some time in jail and has seen the consequences of failing to come to court. And so I would, the sentencing date is set. I think the court could admonish him about the importance of complying with his court obligations. And I talked to him about how the best way to ensure he does not, end up incarcerated long-term in this case is to comply with everything, and to come to court and cooperate with us to fight his case rather than avoid his case. So given that he has a child on the way, he is very young, I think that an admonishment and maybe some non-cash condition could assure the safety of the community in his return to court. So I would ask the court to consider that.
Yes, Your Honor, he has multiple charges in this matter. He's already habeas once. It's shown that they did not let him come to court, so we objected to voting on.
Attorney Kearney, what is he on? He's not being held based on his Third Circuit case.
He is, Judge. He's being held in a $15,000 cash bond in his Third Circuit case, but his sentencing is set for May 1st. And as of right now, he is still slated to get the Cobb's evaluation, which is 2 years of HIDA probation.
Okay.
If I had to speculate as to what Judge Bridget Hathaway is trying to do is to provide an immediate consequence for capiasing and then go ahead with the Cobb's agreement of sentencing is what I think is going to happen, although I don't know for sure.
Mr. Boyle,
Yes, Your Honor.
do you understand the consequences of not showing up to court?
Yes, ma'am.
I want to release you on personal bond. But what I'm going to do, I'm going to also attach a tether, a condition to that, and it won't affect or delay you being released because you are on hold on another case. So by May 1st, you should have a tether. So what I'll do is I will release you on a $10,000 personal bond with the tether. And I want you to understand very clearly, Mr. Boyle, your next court date at 36th District Court. It is May 5th at 10:30 at 36th District Court. Of course, your attorney will let you know that, but I need you here on time. You understand?
Yes, Your Honor. Yes, Your Honor.
And avoiding the issues is not going to help in any way. It's gonna make things even more worse. So just go ahead and address your issues and deal with it that way. So we don't have to keep confusing you and making this harder than it has to be. You understand?
Yes, Your Honor, I fully understand now.
Okay. Anything else?
No, Judge.
Okay, I will see you on the 5th of May.
Thank you, Judge.
Attorney Quinn, good morning.
Deb,
Morning, Judge.
You're all set, Mr. Boyles, you're all set.
okay, thank you. Deb, I'm done.
Okay, Attorney Quinn, you said your client Lloyd is at Walter Ruben?
Yes, she was receiving treatment.
Okay, do you want to waive her presence or are we waiting for her to zoom in?
We're going to waive, ask to waive presence, Your Honor.
Okay. Okay, this is people of the state of Michigan versus Kristen Lloyd. Case 2162344. Ms. Lloyd is charged with one count of robbery armed set for a competency hearing.
Edward's walking P5488, here we have the people.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Kristen Lloyd. Ms. Lloyd is not present. She has been in the custody of Walter Reuther Hospital for quite some time now, receiving treatment due to the orders, the competency order.
Okay, I'm looking at the report. I'm just now seeing this. I have a report from April 18th. Do you have that one?
Yes, I received that this morning and was able to look it over.
Okay, so the recommendation is for her to continue treatment. Is that correct?
That's what I understand, or at least that she has still been determined to be incompetent, and we would stipulate to that finding.
Okay.
The issue is, Your Honor, that I think that it's proper now to move for dismissal pursuant to MCL 330-2034. 15 months have elapsed since the initial order for the competency referral. I believe that was done on or about December 14th of 2021. And the initial evaluation report that I have is dated January 13th of 2022.
Okay, what is the statute you just cited?
MCL 330-2034.
I want to make sure
That is
I
the
have
time limitation on treatment. That is a statute that sets out the 15-month time limit for treatment pursuant to an order issued by the court.
All right, I want to make sure I have the 15 months, what is supposed to happen, or the timeline within the 15 months.
That's the time frame for restoration to competency if it is to happen. So she has been in treatment now since then. And the statute lays out that no combination of orders issued under section 1032 or 1040, which are the orders for competency evaluation, shall have force and effect for a total period in excess of 15 months or 1/3 of the maximum sentence the defendant could receive if convicted, whichever is lesser. And essentially the effect of that, according to the statute, is if the defendant is to be discharged or released because of the expiration of an order under those noted sections, then essentially the prosecutor has the option of petitioning probate court.
I just needed the statute to make sure the timeline was correct with
Oh,
the
sure.
dates in the file.
OIC. Just OIC. So, thank you, sir.
Yes, I can.
One moment, Attorney Quick, I'm providing it to the prosecutor.
Yes, Your Honor.
So she was evaluated on January 13th, 2022. I wanted to find it in the report.
I'm sorry.
January 13th, 2022 is when she was first evaluated. I'm sorry, 2021. Yeah, that's what I was looking for. I know Ms. Attorney Quick stated that, but I wanted to find it in the paperwork. So Attorney Quick, we inherited this case from Stanford Jones. That's why it's taking a moment, because I'm trying to catch up. I'm not familiar with the case. And I just realized she's the one who signed the finding and order of competency for the last hearing on January 9th.
Yes, Your Honor.
So do you have anything down this matter before I address Quick's request?
No, Your Honor. 15 months has run.
Okay. All right, it has been 15 months. I just wanted to make sure and do the math and go through the file, as I just stated, we inherited this from Judge Stanford Jones. So it has been 15 months from the date of her first evaluation. So with that, I will dismiss and fill out an order saying that she is incompetent to stand trial and not restorable.
Very good. Thank you, Your Honor.
And I will have that scanned over to you and to the people as well.
Thank you. Before I sign off, could I ask the prosecutor to put, either give me his email address or put it in the chat? Mr. Kearney was wanting it in the, wasn't able to get it.
Chat counsel.
Thank you. Received. Thank you very much.
Welcome. Have a good one.
Y'all as well.
Mr. Swain,
Yes,
you know you have an exam today in person.
excuse me?
You have a preliminary exam today.
I'm sorry, I can't hear you. It's a little loud where I'm at. Can you say that again?
You have a preliminary examination today in person at 36th District Court.
Oh, I'm supposed to be in person. Okay, well, I never talked to the lawyer that was given to me. I've been calling and reaching out to him. He only emailed me about the case, but I haven't talked to him or anything. And I have been calling him all morning. He hasn't been answering the phone or responding to my text messages.
Okay, give me a moment. What's your check? Okay, Mr. Swain,
Yes.
can you get down to 36th District Court?
Can I get down there today?
Yes.
Not at this moment. I was actually running errands with my auntie. I thought we were was doing this on Zoom, and we're in Dearborn, Michigan.
You have your auntie drop you off at 36th District Court. You do have a court date today.
Okay.
It's a felony case, Mr. Swain. I think it's a little more important than the errand run right now.
I understand. Give me 1 second.
Okay, Attorney Barron, good morning.
Good morning, Judge.
How are you?
I'm good. I'm here on Jaleel Dodson.
I have received your motion. I don't have you on the docket today. I don't remember scheduling the hearing for today.
Okay, I have down that we would be here today for the discovery issue, which was just the unredacted discovery. Is there a different day the court has?
We never scheduled it because I was waiting for the motion from you, the request to schedule it.
Okay, I guess I misunderstood. I didn't even know that I was supposed to file something. I just decided to. Okay, can we schedule it for another day?
You do it Monday because Ms. Parrott, I want to make sure Ms. Parrott is here because she was the one who you spoke with, or that was on the record, correct?
Yep. Okay, that's fine for me.
Let me make sure she's here on Monday.
Okay.
Okay, let's do it Monday. She was copied on the email you sent to the court,
Yep.
correct? Okay.
Yes.
I'll respond and let her know that Monday, what time do you want to do? We have all morning, it's 8:30 moving, every 30 minutes we have an exam, so.
Yep, 8:30 is fine.
Okay, we'll do 8:30.
Okay, thank you, Judge. Sorry for misunderstanding that.
No, I just realized while you were on, I would have called you earlier, so you would.
Okay. All right, thank you.
You're welcome. It is on, it's not on the docket. It's .DODSON, Jaleel dot. All right, I will respond right now, Attorney Barron.
Okay, thanks so much.
You're welcome.
Excuse me, Judge.
Yes.
What's the latest that I can get in?
No, it's not the latest. I need you here in the next half hour.
Okay. Yeah, I'm at the gas station. I came and got something for the kids. So I'm watching the kids for her while she's making her errands. So I have to wait for her to come back. And she's in Grand Rapids and I'm in Dearborn Heights.
I know
And
when I talked.
I didn't know I didn't know I was supposed to be in there today. I would have definitely came in today. I'm not trying to miss out or do anything. I'm trying to make sure I know this the right way.
I always tell everyone when I set their examination, it's in person at 36th District Court.
Okay, I'm
So-
sorry. I missed that. I'm very sorry. I've been going through some things. I just lost my mother, so you know my mind been wandering a lot of places.
I'm sorry about your loss. That's a tough one. If your attorney is not responding, that might be your way out, because if he's not here, then you can't even move forward anyway. So just hold, the clerk is calling your attorney to see what's going on, why he isn't here.
Okay.
Mr. Swain,
Yes,
there's no way you can hear today?
excuse me?
Is there no way you can hear this morning?
No, I can't leave the kids by themselves. They're too young to be left by themselves.
Okay, well, we have to do it, we're gonna have to,
I'm sorry, say that again?
we're gonna have to adjourn your case.
What does that mean?
Adjourn means to, set it for another day.
All right, so we gotta prolong this longer.
Well, I mean, if you were here, we'd be prolonging it.
I understand.
Just like, I want your attorney present, so we're gonna handle another case. Just listen, just stay on Zoom, and you listen for your name. Mr. Swain, give me your phone number.